Hello, everyone. Thank you very much for joining the National Law Center on Homelessness and Poverty and our esteemed panel of housing experts for a discussion of barriers to renting, how discriminatory housing policies harm Americans. Today's webinar will be 60 minutes long. You'll hear in just a moment from Janelle Fernandez, who will go over some housekeeping matters. But before we begin, I want to just quickly introduce today's presenters. The first is myself. My name is Tristia Bauman. I'm a senior attorney at the National Law Center on Homelessness and Poverty. Also joining us today is Kate Scott with the Equal Rights Center, Eric Dunn with Virginia Poverty Law Center, Mark Chatton with Catholic Community Services of Western Washington, and Jith Meganathan of the Western Center on Law and Poverty.
Hi everyone, this is Janelle Fernandez here at the Law Center. Just wanted to go over a couple of quick housekeeping items with you that you can use to enhance your webinar experience. So we will have just a couple of minutes for Q&A at the end of our webinar session. You can submit your questions throughout the webinar through the questions box in your GoToWebinar toolbox, and that's highlighted there on the screen for you. We probably won't have time to use the verbal question option where you raise your hand, but please do submit your text questions throughout the session. Just another note, today's presentation is being recorded, and we will post the video online and share a link to the video as well as a link to the PowerPoint slides with everyone later this week. And back to you, Tristia.
Thank you very much, Janelle. I know that our webinar attendees are at least somewhat familiar with the National Law Center on Homelessness and Poverty, but to give some quick context to this conversation and also some background on our organization, we are a nonprofit organization located in Washington, D.C., and we are the sole national legal organization dedicated to preventing and ending homelessness. An important part of our work is raising awareness about the solutions, enduring solutions to homelessness. What we all know and what the data has made clear over time is that housing ultimately is the solution to homelessness. And there are a number of efforts undergoing now to provide housing to homeless individuals. Some of those efforts have been targeted at certain subpopulations like homeless veterans or chronically homeless individuals, but all housing solutions should be mindful of and designed for the different barriers that may not be immediately apparent that affect homeless people and people at risk of homelessness. And so today's topic is barriers to rental housing. The vast majority of people who are currently homeless or at risk of homelessness are low-income renters or formerly low-income renters and will in the future be low-income renters. And so looking at barriers to rental housing is key when we consider what sustainable solutions to addressing homelessness may be. First, the size of the homelessness crisis in this country. We have a sizable crisis. According to HUD data, and that is conducted in a single night in January 2016, where at a single point in time, homeless individuals are counted, there were 549,928 people counted in the January 2016 point in time count. It's widely recognized that the HUD count is an undercount of the homeless population for a number of reasons, and there are other indicators of the size of the homeless population which suggests that even that sizable number does not represent the full size of the crisis. For example, data from the U.S. Department of Education suggests that as many as 1 in 30 U.S. children are now homeless or will experience homeless over the course of a given year. Also, it's estimated that nearly 8 million people are living doubled up with friends and family in housing, and that's an increase of 67% since the inception of the foreclosure crisis in 2007. In that same time period, we have seen an increase in the number of severely cost-burdened rental households. When we talk about severe cost burdens, we're referring to households that pay over 50% of the total household income on housing. For our purposes, that would be the cost of rent and utilities. There are now over 11 million severely cost-burdened renter households, meaning that these households have less than 50% of their income to pay for other of life's necessities like food, transportation, childcare, clothing, medical costs, leaving that many people and more very vulnerable to homelessness if a single thing goes wrong. And again, there's been a tremendous increase since the inception of the foreclosure crisis in 2007, with the number of cost burden households increasing by 73% since 2007. Some of the reason for the cost burden, of course, is the rising cost of housing. From 2007 to 2015, the median gross rent has increased by 6%, while at the same time, the median income for renter households has only risen by 1%. And for all households across the nation, the median income has actually declined by 4%. And this is all data from the recently released Out of Reach report for 2017 by our great partners at the National Low-Income Housing Coalition. Some of what has contributed to housing rental costs are the historically low vacancy rates. And so what we know is that there are few units for a great number of people who need them. When someone is in housing, it's important to protect their security of tenure and prevent unnecessary evictions. But it's also important for housing advocates, of course, and homelessness advocates to think about barriers to housing re-entry once someone has lost their housing. So we have a great panel of experts that will talk about a number of discriminatory housing policies that serve to bar people from re-entering into the housing that may otherwise be affordable and available to them, further worsening the housing crisis, keeping people out on the streets and shelters or in substandard housing, and directly undermining some of the efforts that are being made nationwide to address homelessness specifically, like rapid rehousing programs. So with that context, I am going to turn it over to our first speaker, Kate Scott at the Equal Rights Center, who will talk about barriers to housing access for survivors of domestic violence. Kate.
Thank you, Tristia. So I was asked to speak today about housing barriers for survivors of domestic violence and how it could be possible for housing advocates to use a fair housing approach in order to overcome some of those barriers on behalf of clients who are survivors of domestic violence, and also in terms of thinking about local advocacy efforts that can be implemented in order to expand those protections for survivors. Next slide, please. So I am the deputy director of an organization called the Equal Rights Center. We are a civil rights organization, nonprofit that's based in Washington, D.C. We have various program areas, including housing, employment, and public accommodations. Our housing program is bifurcated, both locally focused and we do national work as well. Our public accommodations work, disability rights work, employment work tends to be more national in focus. I came to the ERC about 2 years ago. Before that, I worked for a long time in New Orleans, actually, at the Fair Housing Center there. So I say that in order to provide some context. I think in the wake of the last election cycle, we've all been hearing a lot of advice to go local. And to me, as a person that came from a red state, that feels pretty overwhelming, even though I'm currently working in a place that has some of the most progressive housing policy in the country. So I'm hoping to include information in this presentation that is relevant even to those of us that are still working and trying to protect people's rights in areas of the country where that's even more difficult than it is in a place like Washington, D.C. Next slide, please. So I would imagine that most folks on the call already know that domestic violence is a leading cause of homelessness. This is an infographic that I took from a website called domesticshelters.org. You can see there that approximately 50% of all women who are homeless report that domestic violence was the immediate cause of their homelessness. And when you look at homelessness amongst women and families with children, it's a really big problem. Next slide, please. So when Tricia asked me if I would participate in the webinar, there were a couple of different options for topics on the table. And I proposed that I limit my comments to thinking about a fair housing approach in situations where folks are interacting with survivors of domestic violence. And there's a really important law in place, the Violence Against Women Act, that protects the housing rights of survivors of domestic violence. But it has some key weaknesses, and that's why I would like to propose that folks think about also incorporating a fair housing approach in this work. So a short discussion of some of those weaknesses. VAWA is limited in an enforcement sense. There's no private right of action, and there's no ability of an entity to obtain damages as a result of a violation. Also, fair housing laws cover more housing than VAWA does. It's likely that if you're working with homeless populations that are survivors of domestic violence, they're going to need affordable housing, and it's likely that that affordable housing is federally funded and therefore covered by VAWA. But that's not the case in every instance. And the key with fair housing laws is that they cover private housing in addition to federally funded housing. Another thing that's important that fair housing protections offer is that the range of relief is really broad. And so Tricia's comments focused on preventing discrimination against people when they're re-entering housing, but there are actually some forms of relief in the fair housing context that can be used to keep people in housing. For example, temporary restraining orders, lease bifurcations, and in some places where there are specific protections, fair housing protections for victims of domestic violence, early lease terminations are another option. Finally, I would note that with Fair Housing Act cases, you have access to federal courts rather than agencies or state courts. So many states have state court systems that are hostile to civil rights. In Louisiana, for example, we never filed a fair housing case in state court. That would have been a joke. Also, post-November 2016, we know that federal agencies like HUD and DOJ are in turmoil. And what I'm seeing on the ground right now is that they're slow or they're non-responsive to civil rights items. I think over time, we can expect them to become more hostile to civil rights claims. And so right now, at least, the federal court system in many places offers the best possibility of relief in civil rights cases. Next slide, please. So with fair housing laws, there's basically two theories of discrimination. The first is differential treatment, and that's intentional discrimination in a housing-related transaction or interaction that's based on an individual's membership in a protected class. So for example, a landlord tells an interested tenant that they don't rent to families with children. That's an example of differential treatment. The second theory is disparate impact, and that's a policy or practice that's spatially neutral, but has a different effect on a group that's based on their membership in a protected class without a substantial legitimate business justification. So an example of that is actually a case right now that we filed in the district against a housing provider who would not accept Section 8 vouchers. And our claim is that that has a racially disparate impact on African Americans in the district. So that's an example of how that works. I'm going to give another example further on in the presentation, but those are the basic concepts that I think it's important to understand. Next slide, please. So I imagine many of you already know this, but the protected classes under the Fair Housing Act are race, color, religion, national origin, sex, familial status, which is the presence of kids under 18 in the household, and disability. And one note on the sex protection is that there's some recent case law that indicates that sex can cover gender identity too. So These are the 7 federally protected classes. There are lots of locally protected classes in different jurisdictions across the country, but there are also ways to think about some of these coverages more expansively than they were first imagined when they were added to the law. Next slide, please. So in thinking through how there can be fair housing protections for survivors of domestic violence, I wanted to point to this February 2011 memo from HUD. It's actually guidance to HUD investigators about how to assess claims of housing discrimination against survivors of domestic violence or by survivors of domestic violence. So first off, it points to this issue of direct evidence. If a housing provider states a policy that they don't want to rent to women with a history of domestic violence because they always go back to their abusers, for example, that very clearly, this memo says, violates the sex protection of the Fair Housing Act. But then it also outlines the basis for a disparate impact case involving domestic violence. And it cites some statistics there. So for example, in 2009, women were about 5 times as likely as men to experience domestic violence. The memo goes on to state, these statistics show that discrimination against victims of domestic violence is almost always discrimination against women. Thus, domestic violence survivors who are denied housing, evicted, or deprived of assistance based on the violence in their homes may have a cause of action for sex discrimination under the Fair Housing Act. The memo also points out that these statistics can be applied when you think through race and national origin discrimination as well. And there is a caveat in the memo that says that they recognize that men also experience domestic violence, but because of the wide disparity in victimization, and because many of the Fair Housing Act claims will be based on the disparate impact of domestic violence on women, that's the focus of this particular memo. And then it also points to typical types of Fair Housing Act domestic violence cases, specifically eviction and transfer cases, and gives several examples of those cases from around the country. So I think it could be really useful in thinking through this particular aspect of your work. Next slide, please. So this is an example of a disparate impact case using that theory. And this was brought by the ACLU Women's Rights Project based on something that happened in 2012. I know this case settled in 2014. There's a lot more information about it on the ACLU website. But it came out of Norristown, Pennsylvania, which had an ordinance that penalized landlords and encouraged them to evict their tenants when the police were called to the property a certain amount of time for quote unquote disorderly behavior, which included responding to incidents of domestic violence. These type of ordinances are pretty common across the country. And so what happened was that the plaintiff in the case, Lakeisha Briggs, was threatened with eviction after she called the police on her abusive ex-boyfriend. And she became really reluctant to call the police because of that. And she, decided that it was worth it to try to survive the violence that she was experiencing in order to avoid eviction. To the point that in 2012, when her boyfriend attacked her with a brick and she was walking down the street bloodied and on the verge of passing out, her neighbors finally called the police on her behalf and she was airlifted to the hospital. After that happened, the city threatened her with eviction. So the ACLU brought this case and alleged that the ordinance had a disparate impact on women based on the Fair Housing Act. And like I said, the case settled, I think in 2014. Norristown had to remove the ordinance from its books and then also paid a settlement to Ms. Briggs. Next slide, please. So that's, the disparate impact theory is something that's really important to think through, but it also, in this instance, kind of requires you to do some contortions under the law in order to make the case. There are also many places that have local protections on behalf of survivors of domestic violence. So I'm going to talk through 2 of them very quickly in order to get you thinking about, whether or not these exist where you live, and also to think through whether it might be possible to get them in place. So the first I'm going to talk about is the DC Human Rights Act. This added status as a victim of an intrafamily offense in March 2007, and it's probably one of the strongest of these laws that exist in the country. Unfortunately, the regulations implementing this protection have not yet been promulgated by the Office of Human Rights in DC, but I've seen a draft of those regulations, and they go so far as to stipulate reasonable accommodations based on survivors having credit and criminal history that's related to the violence that's perpetrated against them, such that they might be able to, alter the credit and criminal history screening requirements of housing providers. In addition to the overall protections that are included in the Human Rights Act, which really mirror the Federal Fair Housing Act, it also bans refusing to make a reasonable accommodation in restoring or improving security and safety measures beyond the housing provider's duty of ordinary care and diligence. It outlaws refusing to permit a person to terminate the lease on the premises early when they're experiencing violence. And it also explicitly bars limiting the right of a person to call for emergency assistance. So the next law that I want to talk about is actually one that I worked on getting passed in Louisiana. And that's to say, it's great to be in DC. It's really exciting for me because there are all of these progressive protections. But it's actually, the DC Human Rights Act is what we looked at in Louisiana to model a policy there in order to pass some explicit protections for survivors of domestic violence. So the Louisiana Violence Against Women Act was passed by the Louisiana legislature in 2015 after it failed to pass in 2014. Unfortunately, I was not working on the law when it actually passed. I only got to work on it the year that it failed. And what it does is it extends some VAWA-style protections to survivors of domestic violence statewide, even those that are living in private housing. So it allows for things like lease bifurcations. It explicitly allows survivors to contact emergency assistance without penalty. And it states that survivors can't be denied housing based on a history of abuse. I think it's a really important example of a policy victory at the local level. It was based on an eviction case that came into the Fair Housing Center that I worked at, in which the client's uninvited ex-boyfriend beat her until she needed to be hospitalized. And when she returned home, there was an eviction notice on her door based on a provision in her lease that outlawed all illegal activity on the property. And so in lobbying for this bill, we really led with a message about how domestic violence is a leading cause of homelessness for families and how that's very expensive for the state of Louisiana. We also led with a really business-friendly message around making sure that the law is the same across the board, regardless of what kind of housing provider you are. In 2014, the Apartment Association lobbied at the last minute to kill the bill, and they did it effectively. Their messaging was around we shouldn't ask landlords to play the judge and jury in these cases. And that was effective, but with a sustained campaign, we were able to go back the next year and get the law passed. All right, final slide. So these are just some additional resources that I thought it might be useful for people to have access to. There's a link there to the DC Human Rights Act. Also a link to the HUD memo that I covered. There's a link to a toolkit that the ERC released earlier this year. There are some interesting connections between the proclivity of domestic violence survivors to have a criminal record related to the violence. And so this toolkit provides some pointers for consumers about how to overcome criminal record screening policies. And then there's some links to some of the important cases that the ACLU Women's Rights Project has worked on that I think are applicable to this topic. So thank you very much.
Thank you so much, Kate. That was fantastic. And please write in your questions that you may have for Kate and that we'll get to at the end of the webinar. Right now, we will move along to Eric Dunn, who will talk to us about criminal records. Eric, take it away.
Good afternoon. Janelle, could you advance the slide again? And one more, please. Okay, there it goes. Okay, so as probably everyone on the call has heard multiple times before, criminal records is really one of the kind of key civil rights issues of our time. It's estimated that close to 78 million people as of 2014 had some type of criminal record on file with the FBI. I've seen estimates as high as 100 million Americans having some type of criminal record. That equates to between about 1/3 and 1/4 of the adult population of the country. Can we advance the slide, please? So criminal records are something that affects a huge number of people. And if you look more closely at what these criminal records are for, it's clear that the drug war and the problem of mass incarceration, really stems from that. Almost half of people in federal prison are there for drug-related offenses, primarily nonviolent drug possession offenses. Can we advance the slide again? And of course, one key aspect of the criminal records issue is that it is primarily people of color, especially African Americans, who bear the brunt of the problems that criminal records cause. If you look at these two graphs, the red bars represent basically white people and the black bars represent African Americans. The top graph shows the rates of marijuana use between 2001 and 2010, and you can see that the rates were about the same for both white and black individuals. The bottom graph shows the rates of arrest for marijuana possession charges during those same years. And as you can see, your chances of being arrested for marijuana possession were far, far higher if you were African American than if you're white, even though the rates of marijuana use were about the same. So this is one of the reasons that we'll see huge disparities, huge racial disparities throughout the criminal justice system in terms of arrests, convictions, incarceration, and so forth. Can we advance the slide again, please? Nationally, African Americans are more than 6 times more likely than whites to have a criminal record, despite committing offenses at similar rates. And if we could advance the slide again. So this is certainly something that causes problems in just about every walk of life. Not just housing, but since we're concerned about housing today, we'll focus on that. As you can imagine, many rental housing providers adopt policies that treat people with criminal records less favorably than applicants who do not have criminal records. Sometimes that means denying admission to them altogether. You can advance the slide. Those types of policies which treat rental applicants less favorably based on having a criminal record, can violate the Fair Housing Act because of the disproportionate effect that they have, especially on African Americans. You could advance the slide one more time. As Kate talked about, if you have a policy that doesn't overtly discriminate against people based on their membership in a protected class, but it has a statistically discriminatory effect on members of a protected class, then that policy is unlawful unless it is justified by a substantial legitimate interest on the part of the housing provider. Furthermore, there can't be some equally effective alternative by which the housing provider could fulfill that objective without with causing less of a discriminatory effect. So if we could advance the slide again. As we saw, African Americans are more than 6 times as likely to have criminal records as white people. And those statistics seem to hold true not just nationally, but through most, if not pretty much all, more local jurisdictions where people have looked at this. It's fairly easy in these cases to meet the first prong of the disparate impact analysis, showing that policies which treat rental applicants less favorably because of criminal records have a discriminatory effect. But that doesn't automatically mean that those policies are unlawful. it is possible for landlords to justify those types of policies. So what sort of justifications will landlords offer for screening out people with criminal records? It's probably the ones you might expect. Landlords will say that people who have criminal records might be dangerous. They might threaten the health and safety of the other tenants or neighbors or property management staff or other people in the community. The people with criminal records might cause property damage or engage in criminal activities on the premises that could be harmful. And those are probably going to be legitimate concerns, at least facially. But the issue really comes down to is it necessary to screen out anyone with a criminal record or large categories of people with criminal records because of these concerns? And the answer is basically going to be no. Can we advance the slide again? Presumably there are some types of crimes and some people with criminal records who might legitimately be dangerous, but not everyone. And so HUD, in a guidance they issued last year, and this is consistent with what fair housing advocates had generally presumed to be the case, is that some crimes have nothing to do with rental housing, or some crimes have nothing to do with someone's fitness for being a tenant, fulfilling the terms of a tenancy. Some crimes may have had some relevance in the past, but the person may have rehabilitation or changed in certain ways, and it's no longer predictive. Some crimes are directly related to things like mental illness or substance abuse problems from which the person may have been treated and recovered and doesn't present a threat any longer. And so it's not necessary for landlords to screen out people because of criminal records when those records are no longer predictive of what kind of tenants they'll be. You can advance the slide again. Another key factor and if you could advance it one more time to bring up a little circle. One study has shown, for instance, that age is potentially the most predictive factor in terms of whether someone who's committed a criminal offense in the past, at least someone who was an adolescent or in their late teens committed an offense, that by the time they reach their mid-20s, if they've been able to remain crime-free for about 5 to 7 years, their likelihood of reoffending reaches the same level approximately as someone who's never committed a crime before. Advance the slide again. Other studies have shown different types of rates, suggesting that anywhere from about 4 to 7 years for different types of crimes. That if someone's remained crime-free, that they're no longer likely to present a heightened risk of committing an offense. So one of the aspects of the disparate impact analysis is that landlords may not simply rely on speculation or just sort of offhand theories about who they think is dangerous, but their criminal records policies actually need to be supported by evidence and so forth. So we could advance the slide again. So as I mentioned a moment ago, last year in April, HUD issued a guidance, and this was directed not only to subsidized housing providers, but even to private landlords concerning the use of criminal records in screening for rental admissions. And if you practice in this area, it's something that you certainly want to be familiar with. But there are really, I think, 3 key takeaways from the guidance. One is that if landlords are going to be using policies that treat people less favorably because of criminal records, that they need to be relying on convictions or at least have some basis for establishing that the person actually committed the crime. In other words, that if landlords are screening people out based on dismissed arrests, that there's probably not going to be an adequate justification for that type of policy under the Fair Housing Act. Second, that when landlords use overly broad policies to screen out people for criminal records, the term blanket ban, sort of an offhand word that's used to describe policies that might exclude anyone with any kind of criminal record or large swaths of people, such as no felonies or no crimes within 7 years, things like that, where the landlord really isn't making any kind of nuanced determination as to which types of crimes and so forth are relevant to what they think a acceptable tenant would be. The third key takeaway is that HUD does recommend landlords make individualized determinations, meaning that if someone has a criminal record that the landlord thinks it makes that person an unacceptable risk, and the landlord ought to look at the individual circumstances of that applicant and see, what exactly was the crime, how long ago did it occur, is there evidence of rehabilitation, etc., and make kind of a case-by-case decision as to whether to admit that person or not, rather than just having a one-size-fits-all policy. Can we advance the slide again, please? So despite this HUD guidance having come out last year, could you advance it one more time? We continue to see policies that would directly conflict with the main points in the HUD guidance. This is an example of a Craigslist ad that I found just recently. I'm fairly confident that I could find one of these ads most parts of the country anytime I wanted to. This one, it says clean criminal background is required, which I interpret to mean you can't have any convictions, you can't have any arrests, you can't have anything on your criminal record, and it doesn't matter what type of crime or how long ago it was. You would not be accepted at this type of property. So I think what this speaks to is that even though we have the HUD guidance and fairly favorable case law around this issue to advance the disparate impact theory on behalf of people denied housing for criminal records, that there's a real need for enforcement and for people to be bringing cases based on these types of denials. Which leads me to my next slide, if you could advance it, please. Probably the best example of an enforcement case based on this issue going on right now is one in New York City that Relmondane and Colfax is bringing against the Sandcastle Towers, which is a large apartment complex, over 700 units in a part of New York called Far Rockaway, which is alleged to have had a blanket ban, not allowing anyone to move in there who has any kind of criminal record, regardless of the type of crime or the circumstances, the age of the record. So that'll be an important case to keep our eye on. If we could advance the slide again. One of the great things I think about the Sandcastle Towers case is that it presents a good model for how the disparate impact theory can be used to challenge some of these blanket exclusionary policies that landlords have. When we look at unlawful detainer or eviction records, traditionally there have not been the same kind of statistics available to show who gets sued for eviction like we've had with criminal records. But through some recent studies, especially the work of Matthew Desmond, it's become quite apparent that African American women, especially single mothers, tend to face eviction at significantly higher rates than other types of households, and so that could provide a viable disparate impact cause of action on behalf of African American households, female-headed households, families with children, to challenge a fairly common practice that landlords have of denying admission to anyone with any kind of eviction or unlawful detainer record, again, irrespective of the outcome of the case a lot of times. Even if you won your case or it was dismissed, that may still prevent you from getting housing. You can advance the slide once again. So there has been one of these cases recently filed in the Western District of Washington. Full disclosure, I'm one of the lawyers on that case. But a researcher in that case has found that African American women in King County are sued for eviction more than 6 times the rate of white men. So fairly similar statistic to what we see with, at least nationally with criminal records, that, more than 6 times. And so this is a case that challenges a landlord from having a blanket, categorical ban, not running anyone who's ever been sued for eviction, regardless of the circumstances. So again, this will be another disparate impact case, I think, that will potentially have some show how this area of law is going to develop. I think that's my last slide. Yeah, I think I'm out of time, so I think I'll skip the errors on the background check.
Thank you very much, Eric. Just a reminder to all of the listeners that the slides, a recording of this webinar, as well as links to all of the resources that are discussed in this webinar will be included in a follow-up email to all of the participants. So you will get that information. I will make just one note that as we think about the effect of criminal records for those who are working on housing advocacy on behalf of homeless people, when you think about the legislative advocacy that you're doing, whereas some of the arguments that have been laid out by Eric can be helpful, it's also important to remember that homelessness itself is not a protected status under the Fair Housing Act, and there are an increasing number of laws that can result in criminal convictions for people based on their homelessness. I'm referring to laws for that target, for example, sleeping out of doors, camping out of doors, sitting bans, loitering bans that are disproportionately enforced against homeless people. For more information about the criminalization of homelessness, how that can lead to increased numbers of criminal records for homeless people, and the barriers that that can impose to their housing access, you can find that information on the Law Center's website. Switching gears slightly, but looking again at barriers, particularly ones that affect renters in Washington State that have a direct undermining, or that directly undermine homeless rehousing programs like rapid rehousing. I'll turn it over to Mark Chatton. Thank you so much, Mark.
Okay. Good day, everybody. I am the director of legal services at Catholic Community Services, but the main program I work with is the Legal Action Center, which is funded to provide legal advocacy to low-income tenants who are facing evictions or housing subsidy terminations. And a lot of that has to do with the funding to prevent homelessness. But as a side role and an unfunded one, we had been providing limited representation to tenants who had past debts to landlords that were creating barriers to the tenants finding suitable housing. Obviously, debts to prior landlords can be used as a criteria for denying applications. So it's important to try and make sure that these debts that were being alleged actually had some merit. In most of the cases, we'd use the Fair Debt Collection Practices Act or the Fair Credit Reporting Act to request proof of the debt, and in debt collection actions, ask the debt collector to no longer contact the client directly, to only contact us. Next slide, please. Once a debt was verified, then we would attempt to negotiate a lump sum payment or some kind of settlement that was reasonable. But the reality is most of our clients are extremely low income, probably 50% are disabled, so they're surviving on SSI. And these debts really were not things that could be settled given their limited financial resources. On occasion, we might have a client who was getting a tax return, and we could use that as a lump sum payment to pay off the debt and then hopefully then remove the barrier. But for the most part, the Legal Action Center had been providing just really a buffer between the collection agencies and the tenant, again, most of them being disabled, just to have that so that they weren't being harassed by landlords. Provided some benefit. Next slide, please. Now, in the context of public housing and Section 8 vouchers, this becomes a lot more difficult. As most of you would know, debts to former landlords or to public housing authorities can be the basis for termination from the program, either be evicted from the public housing unit itself or have their Section 8 vouchers terminated. this is a huge problem in King County. One of the biggest populations we have that we're serving are Section 8 voucher holders who cannot lease up for a variety of reasons, including that they have past debts on their credit history. We are advocating for tenants whose vouchers are being withheld because a landlord submits a claim for damages. The best example I have right now is a mother, African American, with two children, has a Section 8 voucher, but that voucher is being held by the housing authority because the landlord submitted a letter after the client moved out that said she owed $12,000 in damages. I've requested receipts from the landlord showing that there were actual damages and that they incurred these costs. I have not received anything. The housing authority has not received any verification of the debt beyond this letter that just says she owes me $12,000. I've asked them what proof they have. They have pictures, broken window, a cabinet looks messed up, you know, stuff that happens, but nothing that would amount to a $12,000 debt. But they're holding the voucher, and that voucher will eventually expire. Next slide, please. And they're doing this without giving us a formal hearing process because they're saying it's not a termination, that they're just holding it. But in fact, eventually, when the voucher expires, then the tenant will no longer have a voucher. We're meeting with some of the other organizations in King County that have the potential to use litigation. Our office is only funded to do defense work. So situations like this where we need to enforce our clients' due process rights, we turn to some of the larger organizations here in King County. We happen to be very lucky to have a resource-rich county with massive housing problems. Another debt that comes up that can be very difficult to resolve are tenants who vacate public housing-owned housing. We've had cases where the housing authority will find $6,000 or $7,000 in damages. When you get a breakdown of it, a good example was at one hearing, there was $600 for replacing blinds. I did a quick analysis of blinds. It's like $180 to buy 4 sets of blinds. How come it's $600? And the housing authority representative testified that they pay their staff union wages. So I think there's a cost analysis there that would show that they're not paying their employees that much, but there is no resolution except maybe to litigate it. And again, there's not a lot of opportunities to litigate damages to public housing properties. Next slide, please. So with our past experience being mainly just protecting disabled people from harassment, we noticed also that in the context of times when we had a possible payment plan or a lump sum payment, we were hearing from collection agencies, we're not going to negotiate on those terms anymore. Why don't you send them over to X, Y, or Z, which has a rapid rehousing program. So the dynamics for negotiating had changed. And rapid rehousing, and most of you probably know, is a strategy to rehouse homeless households as quickly as possible. And oftentimes they will do that by locating a prospective landlord who will rent to this homeless family so long as a debt on their tenant screening report to a prior landlord or a judgment to a prior landlord is resolved. If the resolution is completed, then the homeless family will be able to apply for the apartment and will be approved. Next slide, please. Now, this good intentions always results in unintended consequences. And landlords and collection agencies now know there are large pockets of money available to pay off debts and judgments to past landlords. And the fact that there's very little in the way of prevention dollars to prevent people from becoming homeless. Coupled with the potential of this payout, I think many landlords now are seeing or are incentivized to go ahead and proceed with evictions, especially when you know that it's a very vulnerable family, because you may hit a payday if this family gets into rapid rehousing. They'll pay off the judgment, and if you throw on a couple $1,000s of debt for replacing carpet or whatever, a lot of times they'll go ahead and pay that. And there's not really a checks and balances on this. In its current state, especially in King County, which is the only place I really have that much experience with, it amounts to a pretty massive transfer of financial resources from nonprofits to collection agencies and past landlords. Next slide, please. Well, this does create an opportunity, both for rapid rehousing programs and legal services programs that are dealing with homeless issues. Many of these case managers have not received training on the issues around debts and judgments. Many of the judgments are paid, but the case managers are unaware that a satisfaction to judgment needs to be filed. And then collection agencies, knowing that these folks really aren't trained, are sending obsolete debts that are over 7 years old. I've seen one that came across with a 10-year-old debt, and they were going to pay it until I mentioned that it's no longer collectible. Next slide, please. So after a couple of years, the strategy, tenants who were housed in the initial start of the rapid rehousing program may be relocating now, and they're finding out that those judgments are still on there. And because the judgments are still on there, prospective landlords are refusing to rent to them, even though they can provide some evidence that the debt was paid. Collection agencies, credit reporting agencies look to the court files to see if those judgments are satisfied. And without a satisfaction to judgment, it's still going to be a barrier. Now, we started working with our rapid rehousing program at this agency. And I also conducted a pilot project earlier this year in the hopes that I would get funding for this. And I found that these problems exist across the system. Several programs came to me with satisfactions of judgment that needed to be done. Some of them were other issues. And there's the legal issues that arise out of this doesn't just involve, hey, get me a satisfaction of judgment. We have all sorts of issues that come out, including like when a judgment creditor is deceased, or it was a corporation and now that corporation is disbanded. How do we deal with that? How do we resolve this? And then just making sure also that the landlords we're renting from are complying with the Residential Landlord Tenant Act. Now, what I found is in this short period of time that I've been doing this work, that working with the landlord tenant bar, if there's an attorney on the other side and it's a judgment, I can resolve that very quickly. And it's one of the pleasures of my job to have somebody from rapid rehousing come down and say, I've got a problem with this case, and I get on the phone and solve it in 5 minutes. That goes to show that this can be a very productive relationship. And the second part, though, is collection agencies, working with collection agencies. We've got to figure out a way to deal with this satisfaction to judgment issues, because they tell us, oh, it's 30 to 60 days until we'll file the satisfaction to judgment. And that doesn't work for rapid rehousing, because that means that judgment's still there for another 30 to 60 days. The whole point of this was to get people back into housing as quickly as possible. So given that there are probably a lot of programs out there, rapid rehousing programs, that aren't getting any kind of legal assistance or advice on how to handle some of these more complex issues, I'm encouraging legal services programs, if you have a robust rapid rehousing program in your county or city, to contact them and see if they are getting some of these issues resolved, or if not, propose that you be included in their next contract. That's what's been happening for my program. Despite the fact that we have a housing crisis here in Seattle, Getting prevention dollars for lawyers to stop evictions is incredibly challenging. This offers an opportunity where there's much more funding available, and we can show that there are ways to make the use of that funding much more efficient and effective. And that's all I have.
Thank you very much, Mark. We are now about just a few minutes from the end of our scheduled time, but we are turning it over to Jith Meganathan, who will discuss eviction ceiling, which obviously is a very important issue. I'd invite everyone on the call to stay over for a few minutes. Jith has around 10 minutes or so of content, and for those willing to stick around, we do have just a couple of questions that I'll pose to the speakers. So please feel free to stay with us for another 10-15 minutes. Jith, thank you.
Thank you. I'll be as brief as possible. I am a policy advocate at the Western Center on Law and Poverty in California. I focus mostly on legislative and administrative advocacy in Sacramento. The issue of tenant blacklisting through tenant screening reports is an issue, I think, in every state in the country, and I just want to describe a successful reform effort that we were able to enact last year. Next slide. Next slide, please. Okay, so tenant screening reports identify individuals who are named as defendants in an eviction lawsuit. And while the existence of tenant screening reports altogether is a problem, one of the major problems that we see is that mere involvement in an eviction lawsuit is sufficient to lead to blacklisting. It's not just folks who lose an eviction lawsuit against whom an adverse judgment is entered. The tenant screening companies go to every court in our state every day and write down the names of every defendant who's named in those cases. And there are at least 7 of these services in California. Landlords who subscribe to these services screen prospective tenants against these lists, and they therefore effectively function as tenant blacklists. And what happens is that the applicant is either charged an exorbitant security deposit in order to rent, or simply denied the opportunity to rent altogether, which leads to homelessness, particularly in a state that's has a housing shortage and rents as high as California does right now. Next slide. So in trying to reform the current state of affairs, we ran up against 2 major constraints. The first is that tenant screening reports are governed by the Federal Fair Credit Reporting Act, which has 2 significant consequences. The first is you can only challenge the accuracy of the information in a tenant screening report. That is, if you were not actually named as a defendant, you could challenge your inclusion in these. And we've seen cases where tenant screening companies were so overzealous that they were writing down the names of tenant attorneys and recording them in blacklists. So those attorneys were able to challenge the accuracy of their inclusion since they weren't actually named as defendants. But people who were named as defendants could be listed. The second is that the fact of the eviction lawsuit can be reported for up to 7 years after a lawsuit is filed. So this, once you're on such a list, you stay on there for 7 years, and it has devastating consequences for that period of time. Next slide. The second constraint that we faced is that under California law, the information that was disclosed in a tenant screening report became subject to First Amendment protections, so that we were not successful in challenging the ability of tenant screening companies to publish information once it entered the public record through court records. But the court that decided the case that I'm citing here helpfully said that if the state is concerned about dissemination of this information, it has the power to control its initial release. So any legislative solution that we were attempting had to focus on what information was going to be disclosed in court records. Next slide. So the way that the law existed prior to the bill that we ran, AB 2819, records in eviction lawsuits were initially sealed for 60 days. At the 60-day mark, courts would look to see whether a tenant had prevailed within that 60-day mark, and if they had, the records would remain sealed. But if they had not prevailed in that time, the records became public. And this is the way the law had been for about 25 years, from the early 1990s. That was the last time that we had attempted to reform this law. Prior to that, everything became public on day 0, and all defendants were screened out regardless of how their lawsuits went. There were 3 consequences of this. The first is that there were zombie lawsuits that were leading to blacklisting. Essentially, the landlord would file a lawsuit, the parties would work out their differences, or the landlord would decide not to pursue the case, but the landlord never dismissed the complaint. On day 60, the lawsuit would become public and the defendant would become blacklisted, even if they remained in that housing. The second was that this had a chilling effect on many tenants' willingness to pursue meritorious defenses. Our courts are very congested here in California, and if you were to litigate a defense and potentially go to trial, you might edge out past that 60-day mark and end up blacklisted even if you won your case. And that goes to the third point as well. Because of court delays, the tenant may have decided to pursue their meritorious defense, but prevailed after the 60-day mark and ended up blacklisted as well. Next slide. So after a lot of work, we were able to pass this bill, AB 2819, so that as of January 1st, 2017, records are initially sealed on filing in eviction cases, and now the landlord has to obtain a judgment within 60 days of filing the eviction lawsuit for the records to become unsealed. Alternately, if the landlord prevails at trial after the 60-day mark, the judge's order specifies that the records are to become unsealed and the records can become public in that case as well. Otherwise, the records remain sealed. So essentially, what we hope we achieved here is that only people with adverse judgments or who lose at trial after the 60-day mark, only their records will become public. Next slide. So a lot of things had to go right for us to pass this bill, and I'm just going to briefly run through some of the key ones. The first is we had to work with the judicial branch in order to ensure that this bill wouldn't incur any fiscal costs, which would have increased the chances that it either wasn't approved or that our governor would veto it. So working with that 60-day mark that was in the prior law was key, and the courts concluded that it would not require a great deal of reprogramming of their systems in order to accommodate this law, and therefore it was not tagged with a fiscal cost. The second, I know this is easier said than done, but we engaged in almost 5 months of negotiations with the landlord lobbyists before we were able to get at least some of them to go neutral. The key was that they wanted to reduce the number of trials, particularly in There are a few jurisdictions in California where every tenant has a right to a lawyer under our Sergeant Schreiber Civil Access to Justice pilot project. And they felt that the provision in the bill that said that if the tenant lost at trial after the 60-day mark would reduce the incidence of tenants taking matters to trial, perhaps if they did not have meritorious defenses. And they felt that that was enough of a win for them that they were able to go neutral on this bill. A third thing we did is that we simultaneously ran a much more controversial bill, in this case, a voucher non-discrimination bill. This was not intentional, but as a side effect, many legislators who otherwise probably would have voted against this turned to the landlord lobby and said, look, we already dealt tenants a blow by defeating the voucher non-discrimination bill. I think we're going to give them something with this. Fourth, we frame this as a credit reporting reform bill, not as a tenant protection bill. And that was something that people were able to relate to much more, because a lot of people have had errors on their credit reports that made their lives more difficult. The fifth is we found an amazing, charismatic victim of blacklisting who was not at fault for her eviction. Of course, everybody, nobody should be harmed by tenant blacklisting, but again, framing is everything in legislative advocacy. And in this case, the tenant, her landlord had filed an eviction lawsuit. She had a meritorious defense, and then the landlord was foreclosed on, so she never had an opportunity to present her defense and ended up homeless for a long time with her 6-year-old daughter as a result of this blacklisting that she had no control over it at all. And she literally brought some legislators to tears when she testified. Finally, we found victims and allies among veterans groups and labor groups, and they were able to appeal to particular legislators for their support. So those were all important strategies that worked in our favor. Next slide. So that concludes my presentation, but I'm happy to answer questions here or follow up with me afterwards. Thanks.
Thank you very much, Jith. This is Tristia Bauman again. Here's my contact information. I know that there are a couple of short poll questions that Janelle Fernandez will be asking the audience members to help us ensure the quality of the content that we present to you in our webinars. I'll ask the speakers to stick around just for 3 questions, which should take maybe another 5 minutes or so after we complete the survey questions. Thank you everyone for joining us and for sticking around to hear the answers to the questions. Janelle?
Thanks, Tristia. So thank you to everyone who has stuck with us through the webinar. Like Tristia said, we just have 2 really quick survey questions that we would like to ask of you. The first is, as a result of this webinar, do you have a better understanding of the topics that we've discussed today? The options are yes, a lot, yes, a little, or no, not really. And if you could, please just go ahead and click right on the survey question on your screen and let us know if you found the material that was presented today helpful to your understanding of these topics. And I'll give folks just a few more seconds to log their answers. If you haven't responded yet, please go ahead and just click right in that survey window on your screen there. All right, so let me close this poll out and I will share these results with you. And it looks pretty good. So 62% of you said yes, this was a lot helpful, 37% yes, a little, and just 1% no, not really. So thank you to everyone who responded to that. And we have just one more question. Let me share that with you. And this question is, will you use the information that you learned today in your work or advocacy going forward? Your options are yes, no, or not applicable. So one more time, if you could just respond to that polling question by clicking right there on the screen. This will just help us know how helpful this information is and if it's being put to use, and help us design future webinars to be helpful for you as well. So I'll give just a few more seconds for folks to respond. Okay. And this is great. 100% of you that responded said, yes, you will be using this information in your work going forward, which is fantastic. That is what we love to hear. So thank you all for responding to those surveys, and I will pass it back to Sia for some Q&A.
Thank you. I really appreciate everyone sticking around. Just a couple of quick questions. First, for both Eric and Mark, who worked on Washington State's law that allows for limited dissemination of unlawful detainer records. If you can talk maybe first, Eric, about what that law does, maybe a couple of points about the strategy that was used to get that law to pass, and then I'll turn it over to Mark to talk a little bit about how it is functioning in practice since enactment.
Yeah, I believe there's a slide on that one. I don't know the number, but it's the one involving RCW 59.18.367. If you're able to find that and pull it up, it'd be great. But basically, I thought Jist's presentation was great because a lot of the things that he recommended were things that, had happened in Washington as well. The way that this law works is it allows unlawful detainer cases to still appear in the court record system so the public can find them, but the court may enter an order on behalf of a defendant in an unlawful detainer case, providing that that case is to be of limited dissemination. And if the court enters that order, making the case of limited dissemination as to one or more of the defendants, then a tenant screening company is not allowed to report that case to a landlord in a tenant screening report dealing with that defendant. We would love to have had a California-style law that simply sealed the records from the public's view altogether. The reason the California approach is kind of superior is because one of the shortcomings in the Washington law is that if you have a landlord who looks up the applicant himself or herself using the court system's database, they'd be able to find the record of the case. This only limits what tenant screening companies can report. So, the California law, which the public can't access the information, provides even better substantive protection for tenants. But in Washington, as in some other states, in fact, Washington has a state constitutional provision which provides for the open administration of justice, and that extends to open public access to court records. And what that means is that in order to limit the public's access to any kind of court record, even someone's name in a judicial database, you have to meet a very exacting strict scrutiny type test. So we had actually attempted to do that in a couple of lawsuits, and we had some limited success. But eventually there was a case in 2015 called Untitled versus Encarnacion, and we lost 4 to 1 with the majority, or I guess plurality actually, ruling that the public's interest in access to eviction records was more important than protecting tenants' ability to get housing when they were wrongfully sued. And in fact, the majority even started off their opinion by saying that our clients in that case had a valid lease and had done nothing wrong to deserve being sued for eviction. So it was a really tough loss, but we did get some favorable language in a footnote in that plurality opinion, which said, well, the legislature can do something about this. And so that kind of provided us an opening to get this limited dissemination law. Another constraint besides it's just explained in California, the contents of a tenant screening report are considered to be ordinary speech subject to the First Amendment, again, under a strict scrutiny analysis. In most of the country, any kind of consumer report, which would include a tenant screening report, is considered commercial speech, and so it's subject to a less rigorous analysis. So if the state imposes restrictions on what can be reported, you don't have to survive strict scrutiny. It's something called a central Hudson analysis. So we didn't have to worry about that constraint. Some of the other things we had going for us, we did have a number of tenants who had, very unfair eviction records who were able to testify. We were also running other legislation that was more far-reaching. For instance, we had bills that would have created something called a portable tenant screening report, so that you pay one screening fee and a report is created about you, and then you can shop that report around to different landlords for a 30-day period without having to pay another screening fee if you get turned down somewhere. And landlords didn't like that, so this was something that they felt like they were going to eventually have to agree to something, and they could swallow this. So I think I've probably gone on longer than I should have, so I'll turn it over to Mark to talk about how that law is working in practice.
Well, actually, Eric, your timing was perfect, because the law we're just really working out the kinks, figuring out what are the grounds for limited dissemination. Our office has not been able to jump into the fray with that, although it definitely is something that we should be filing on behalf of our clients. At this time, we just really haven't had many opportunities to do so. The one case I am aware of that did get an order of limited dissemination is an African-American mother with children, and she continues to find that landlords are, as Eric says, they're going on their own and looking into SCOMAS. I think vulnerable households have to expect that they're going to get a higher level of scrutiny for those kind of those screening reports. And for the most part, most evictions will not qualify for limited dissemination. So its impact right now, it's hard for me to say that it's having much of an impact. I'm still working through that process and seeing cases that have gotten limited dissemination orders, but still are finding difficulty in finding housing. And that's what I have on that.
Great, thank you very much. Switching gears, talking about strategies to get information once a law has been passed, and or even in the absence of a specific state statute, the application of the Fair Housing Act, for example, to some of these blanket screening policies. Are there any strategies that the presenters have used to get information about the legal problems related to blanket screening policies to landlords? And how should those strategies be adapted in large cities versus smaller rural areas? And that's for everyone.
Tristia, this is Kate. I just want to make sure I understand the question. It's what are the strategies that any of us have used to get information to landlords about blanket bans being problematic?
Yeah.
So the toolkit that I mentioned that the ERC published earlier this year, one of the recommendations that we make for people to consider is that they provide their landlord with, if they are rejected based on a blanket ban, that they explore the idea of providing their landlord with a copy of the HUD guidance that Eric referred to. That is something that we try to make clear is, up to the decision of the individual tenant. But for a lot of folks that have criminal records, they're being turned down in lots of different places at the same time. We interact with people who have no interest in living in a place once they've been rejected. But we also interact with some people that, really want the unit. And so we have had some success with tenants providing a copy of that guidance. We've also talked about the idea of our intake coordinator sending something like an advocacy letter, the same way we would in a reasonable accommodation or reasonable modification situation, to a landlord, because sometimes, something coming on official letterhead from an agency that people know is involved in litigation can help. So I don't think that that's something that should be discounted. And, I can't say that it works in 100% of the cases, but it's an option.
Some of the things that I've been involved in, when I was in Washington, the Tacoma Fair Housing Office and also another organization in Seattle would put on landlord trade show type things, conferences, and they would invite fair housing advocates to speak sometimes. And so I would give presentations to them. A lot of times they were pretty hostile crowds. They didn't want to necessarily hear what I had to say, but you could at least put this issue in front of them. When I was in Washington, I had an article published in the state bar magazine that goes to all attorneys called Rental Housing's Elephant in the Room, basically pointing out that it looked like landlords that were using these blanket no evictions policies were probably violating the Fair Housing Act, and the only thing we didn't have to prove it was the data. And that article had been recirculated in the landlord publications and so forth. So I think that may have been helpful in getting some of their attention. And then with criminal records, the organization I work for now, the Virginia Poverty Law Center, we're working on a report that we're going to send out to subsidized housing providers and to low-income housing tax credit properties in Virginia, where we've basically analyzed their criminal records policies, and they're pointing out how we feel like there's not very good compliance with the HUD guidance in terms of their criminal records policies, and hopefully that will, get some of them to reform their policies, for fear of enforcement.
Great. Well, thank you for those responses. I think those are some very helpful ideas for how to get at the landlord audience. We are unfortunately so far over time that I don't think we can get to the remainder of the questions. Thank you to all of our panelists for the great information that they provided to us today, and to all of you who have joined us for today's webinar. Please do feel free to contact the Law Center with any questions that you may have about our work generally or about the content of this webinar. You also will receive, as I mentioned earlier, an email with the links, the webinar recording and the presentation, and the materials that are referenced in today's webinar are all going to be included there as well, and I'm sure our presenters would welcome your questions about their presentations. Thank you, everyone, and have a great day.